Good evening, ladies and gentlemen. On behalf of the International Relations Committee of the Bar Association of Sri Lanka, may I warmly welcome you all to the webinar today on transnational contracts and the impact of COVID-19. To talk about this topic, we have a very eminent and able speaker tonight, Dr. Belen Olmos-Gipioni. She's an associate professor of law and head of law at the Kingston University of London. I think a formal introduction of the speaker will be done by our moderator this evening, Dr. Asanga Gunawansa. Need no introduction of Dr. Asanga Gunawansa. He's a PhD holder from National University of Singapore, and also he holds an LLM on international arbitration from University of Warwick, United Kingdom. So without much ado, let me also share with you some of the housekeeping messages on behalf of the International Relations Committee of the Bar Association. Today we are talking about this transnational contracts and the impact of COVID-19, how it had impacted the international contracts with regard to transnational contracts. And also on the 16th, we'll be having another session with regard to arbitration, international arbitrations, with collaboration with the International Arbitration Center in Kuala Lumpur. And that session will be conducted by none other than Datuk Professor Sundar Raju, joining us from Malaysia. And also thereafter, on the 16th, we'll be talking about cryptocurrency and Bitcoins, which is quite a new topic to our audience and the related law. And we'll be having that session on the 19th of November this month. With that, let me now hand over the podium to Dr. Asanga to conduct this session on transnational contracts and the COVID-related impact of COVID on these contracts. Over to you, Doctor.
Thank you, Janaka, for that. And let me first welcome Dr. Belen, a very good old friend of mine. Belen, it's a pleasure to host you at least for an online webinar, although we have been planning to do it for quite some time, you know, by inviting you to come over to Sri Lanka to talk to us. I'm sure we can do that in the future one day. So as Janaka said, Belen is an associate professor and head of law at the Kingston University in London. She is also an arbitrator with the Madrid Chamber of Commerce. She is also a barrister qualified in Spain, and she had a whole heap of qualifications. So in order to save time, I'm going to very briefly, you know, say some of the things. She has been a visiting fellow at the University of Cambridge, the Institute of Advanced Legal Studies, as well as Stanford Law School in the US. She is the co-convener of the interest group on international business and human rights at the European Society of International Law. Belen's research interests include international economic law, international dispute resolution, and environmental law. She has authored several articles in peer-reviewed journals, as well as book chapters in the area of environmental law, trade agreements, investment protection, dispute resolution, free trade, and human rights. And I would also take this opportunity to say that Belen also was one of the contributors to a book that Belen and myself and several others did for the government of Sri Lanka some time back, government of Singapore some time back on water privatization. So Belen is going to speak to us today on transnational contracts and the resolution of COVID-related disputes. As all of you know, we are living in a very difficult time, and getting used to the new normal is not easy, and it is not going to be easy, both in our professional lives, business lives, as well as private lives. Severe challenges have been created as a result of the COVID-19 situation and having major impacts on commercial and contractual transactions. So Belen will address us today on these impacts from a legal perspective, and perhaps offer her views on some of the solutions. So thank you very much for joining us. And Belen, over to you, please.
Thank you very much for the invitation. I would like, first of all, to thank the International Relations Committee of the Bar Association of Sri Lanka. Apologies that I had to postpone the seminar for work-related reasons. And of course, the topic for today's presentation is quite relevant. So I chose to talk about transnational contracts, thinking about those contracts in which we have an international element, and contracts in which we have usually delocalization or denationalization by way of an arbitral or arbitration clause. So before going to the presentation, I have some slides prepared for today. I think it's important to make some general considerations about the COVID-19 crisis from a contractual law perspective. Of course, for full disclosure, as you may have heard, I was trained in a civil law country, but I'm in a common law country, and therefore I apply common law in my daily life. So my presentation will draw on both legal systems, right? But of course, with a more emphasis perhaps on English law. So I think that the problem with COVID-19 and contract law is how we categorize or define from a legal perspective the public emergency that was brought by COVID-19. And of course, COVID-19 has brought several consequences and impact on different sectors, but we can see a general impact on a wide range of contracts. I will focus, for the sake of the explanation, on the international sales of goods and on construction contracts, but we need to bear in mind that this is a quite major event. So the question here is how we can deal with COVID-19 crisis from a contract law perspective, and how we can address the crisis through the different legal institutions. Of course, we need to bear in mind as well, what is our cutoff date? What is the date that we are taking into consideration? We have a pandemic. A pandemic is usually considered under different legislations a force majeure event with different types of provisions, sometimes contractual provisions, sometimes legal provisions. So we have one date, which is the 11th of March 2020, on which the World Health Organization decided to call this a pandemic. But nevertheless, we could see the effects, if we're thinking in terms of the impact of the COVID-19 pandemic already happening in December 2019. So when we are talking about contracts, so sometimes the cutoff date is taken as the 11th of March 2020. Sometimes we have the cutoff date in December 2019. And this is relevant in terms of assessing what are the possible solutions there for contracts. Also, I would like to draw the distinction between the different possible solutions, which depend on the legal framework that we are using to examine the contract. Clearly, the contract is the law of the parties, so therefore the first thing that we need to do is to have a look at the contractual provisions. The contractual provisions, as we will see, sometimes include a force majeure clause, which provides for unforeseen or unforeseeable events, such as a pandemic. And we have sort of a standardization in this regard. The International Chamber of Commerce, for instance, has provided us with a very good clause in its 2003 version, but we have a new clause from March 2020. So that's the first source that we need to look at in order to determine what is the solution. The second source is the legal framework, the particular governing law or applicable law to the contract. And here we have different solutions depending on the legal system. In common law, we have the solution of the frustration of the contract, hardship, being the frustration of the contract, quite, I think, extreme solution, which requires, in the face of the impossibility to perform the contract, a very, very hard threshold. And the contract then is terminated as a matter of law. In civil law countries, and here there is a difference, we've got other doctrines, as I will soon explain to you, which are the force majeure, but a different consideration from a different viewpoint. Force majeure understood as the applicable law, or force majeure as regulated in the civil codes. We have as well the clause rebus sic stantibus, which is a fundamental change of circumstances, which also requires a threshold. And these two clauses, both force majeure and rebus, from the perspective of civil law countries, are in the codified laws, the civil code, the commercial code, which is something that becomes quite interesting when we are talking about, for instance, international or transnational contracts between an exporter located in Sri Lanka and an importer located in Italy. So I was having a look at PricewaterhouseCoopers report on Sri Lanka, and we know that the construction of the government sectors have been severely affected by the COVID-19 crisis. And one of the main destinations of the exports in terms of the government sector is Italy. So in Italy, for instance, the local party, depending on the governing law, could invoke force majeure even if the contract does not provide for it as a clause. So these are the different approaches to how to deal with the COVID-19 crisis from a contract law perspective. We have as well different remedies. We can be thinking about the suspension of the performance of the contract. We can be thinking about the recalibration of the contract, cost adjustments in the contract. We can also be thinking about the preclusion from termination of the contract if we want the contract to be still valid and enforced. And as the last resort solution, we can be talking about the termination of the contract, bringing the contract to an end. So I think that in all what concerns the COVID-19 crisis and contracts, there is at the moment this idea of renegotiation, the rebalancing of the contract, right, rather than resorting to a solution such as termination, right? That would be the solution, for instance, under frustration. So after this general introduction, I would like to share with you the slides, and I hope that you can see the slides. So in my presentation, as I said before, I would like to focus on two different sectors. On the one hand, the government, the international sales of goods sector, and the global value chain sector, and then on the construction sector. Of course, the main caveat here is all what I'm going to say are reflections about possible solutions. At the moment, there is an emerging court litigation and also arbitration with regard to all these issues, but we don't have final solutions yet. With that caveat in mind, the caveat that we are clearly navigating uncharted waters, so we'll try to deal in what I have, the time that I have allocated with these different issues. So, of course, as I was saying before, the impact of COVID-19 on contract performance has different nuances depending on the regimes and the solutions given across the states. We can be talking about force majeure, as I mentioned before, rebus substantivus, hardship, frustration, and we can see these different approaches with regard to the context for the international sale of goods and the in particular entangled in these global value chains. And I think this is quite relevant for Sri Lanka. And then the effects on construction contracts. So of course, there are different types of construction contracts. I don't have time to address all the different solutions, but I will draw some general considerations about what is the impact of COVID-19 on construction contracts. And I will conclude with some thoughts about the COVID-19 related dispute resolution. As I mentioned, there is already an emerging court litigation and emerging arbitration, COVID-19 related, and it would be quite good to do that exercise of thinking about where can we go if we are lawyers and if we have a client with a problem related to contract performance originated as a result of the COVID-19. So, and if I have time, I will conclude with some remarks as a food for thought. So, of course, the current scenario, we are all aware of it, right? This is an unprecedented crisis due to a global pandemic and with clear ramifications in different sectors and affecting transnational contracts. Is it something new? Well, of course, I mean, we have seen the different comparisons with, for instance, the Spanish flu and so on. But it's new in terms of the effect and the scale. So we had 2 previous outbreaks and that we can use as sort of a comparison or comparators, right, with regard to this pandemic from the viewpoint of the legal effects, the H1N1 outbreak in 2009-10, but definitely that one was quite reduced in terms and restricted in terms of the spread and in terms also of the effects. There is another epidemic, not a pandemic, but another epidemic that is also used as a predecessor in terms of the legal solutions, which is the Ebola outbreak in Africa. But again, this is a regional epidemic, not a pandemic. Nevertheless, there are some solutions given there that we may use for this pandemic. A global pandemic with different restriction and control measures applicable across the states, lockdowns. In the UK, we are facing the second lockdown, and with different measures across the sectors. I was mentioning before the presentation that, for instance, the construction sector is a sector in which we have seen different types of measures. The construction sector, the construction did not stop at once. Right? There was no, in some countries, no blanket prohibition, right, to go on with the construction, right? But then progressively we have seen the different negative impacts on the construction sector. And I think that the COVID-19 crisis highlighted what we can call the strengths and the weaknesses of transnational contracts, right? So, and also revealed more vulnerabilities, not only legal vulnerabilities, but also social vulnerabilities, right? So not all the states are in the same situation to deal from a legal viewpoint and also an economic viewpoint with the crisis, right? So we have some direct impacts due to the health precautions problems and the social distancing rules on the supply and demand side. If we're talking about the garment industry, for instance, here in the UK, all the textile shops, right, in the fashion and textile industry are closed again. And some indirect impacts, right? So we have disruptions, right, in terms of international transportations and networks and the restrictions, right, and the movement of people, right? So we have an increased financial volatility. So several indirect impacts, right? So we need to see how we address these different impacts from a legal perspective and from a contractual perspective. So, of course, it is true that transnational contracts are not more vulnerable than other contracts, and this is what I would like to advocate for today. We can have resilience from a legal viewpoint based on long-term contractual relations and a renegotiation of the contracts, right? But clearly, there are different effects on markets per sector and countries, right? So some non-traditional exporters have grown, whereas in other sectors, such as the garment sector and the construction sector, we are seeing clearly more detrimental effects, right? So these drawbacks force us to think more creatively and to find a legal solution, right? Legal response, right? What are the contractual remedies that we will be using to address these different issues? Because clearly we can predicate in favor of the termination of the contract, but is this really what we want? If there is, for instance, not only a legal issue or an economic issue there, but also a social issue, are we going to take that solution, which can be extreme in some cases? So we have different ways to deal with the COVID-19 crisis in contract law. All the different solutions, I think, they share one common root, which is the principle of good faith as a legal principle, right? Advocating the proportionality between the different contract performances and fairness between the parties, right? The good faith principle, which is also used as a tool for the interpretation of contracts, right, can have different terminologies, right? So as I was saying at the beginning, in civil law countries, we have pacta sunt servanda, rebus sic stantibus, imprevision, in the French doctrine. In common law, we have force majeure clauses, hardship, and frustration. And we have attempts right there to have harmonization, to have a set of principles applicable to all different contracts, right? So you have there the Article 6.22 of what principles, right, which refers to hardship. So, and I think in this case, what I would like to underline are the three different elements that we see in force majeure as well. So for the clauses to apply, right, the events should occur or become known to the disadvantaged party after the conclusion of the contract. The events could not reasonably have been taken into account by the disadvantaged party at the time of the conclusion of the contract, unforeseen or unforeseeable, and they should be beyond the control of the disadvantaged party. And finally, the risk of the events was not assumed by the disadvantaged party. So these four elements are quite crucial because we will see these elements in the different legal responses. And the unilateral principles advocate for the right to request renegotiation. As I was saying before, termination should be the last resort. We need to advocate for renegotiation of the contract. In the case of the international sale of goods, we have in the Vienna Convention in 1979 the impossibility of performance in case of an impediment beyond control. So clearly COVID-19 is beyond the control of the parties. But the question here is to determine what is the scope of the pandemic in terms of force majeure. What are the different costs which are covered and the different obligations which are covered by force majeure? And I think that really there we have the problem sometimes. So of course, if we delve into more detail with regard to force majeure, we have an extraordinary event that occurs outside the activity and operation of the responsible party or debtor. It leads to a violation, a breach of contract, right, which is inevitable. It cannot be avoided. And we have from the doctrine of force majeure events which are considered acts of God, right? And with three different elements there: enforceability, the causation. Causation is quite key here, and this is something that we need to bear in mind, in particular when we are determining the scope of the application of force majeure. There must be a direct link between the event we are claiming as triggering event and the losses or the loss, right, suffered by the party, and it should be unsurmountable, so cannot be avoided, right? Of course, there is also a question there about should we also apply a test of reasonableness or loyalty, right, in terms of like having a look at the proportionality, right, and in light of the contracts, right, having a look at if there is an equilibrium there in the contract, right. And I think we need to also bear in mind, and this is more from an international business and human rights perspective, right, the secondary duties in international business law, right, the duty to care, cooperate, and inform the other party. So in English law, this is something that is shared across the civil law jurisdictions, right? So, and as I said before, we have in civil law jurisdictions clauses in the contracts, but we have as well force majeure in the civil codes, right, codified. In English law, in contrast, we have force majeure as a clause of a contract. So if we don't have force majeure included as part of the contract, as one of the contract provisions, we cannot rely on as majeure. So therefore, the contract wording is crucial. So we don't have established settled meaning of force majeure. Every force majeure clause should be interpreted depending upon the words used in the contract. And of course, in this case, we have whenever we can demonstrate that a force majeure clause is included, and that force majeure clause applies, because sometimes we have a force majeure clause, but nevertheless we're not able to prove the application of the clause to the particular event. That would entail suspending the obligation to perform a contract, right? Of course, there are different issues there. We need to have a look at what is the duration of the event triggering, right? The application of the clause force majeure, because if the duration is, and this is something that we are facing at the moment, we don't know until when we will be having lockdowns and restrictions and social distancing measures. If the vaccine is ready now, and then perhaps by spring 2021, we will get back to a normal situation, which will be, in any case, a new normal. So in English law, as the force majeure clause provision is a contractual provision is understood to be an exception to the rest of the performance of the obligations, it should be interpreted and construed strictly. So that's why in some cases, even if we have similar events, courts have decided against the application of the force majeure clause. So of course we have force majeure, we have hardship as well when it becomes more onerous to perform the contract. They are different and also inspired by this idea of equitas and good faith. But however, we have force majeure with that specific meaning, right, in terms of the clauses, as advocating or allowing for the exception from liability, and in certain cases, the termination of the contract. Right? So, just to recap on what I have said, right, certain conditions should be met, right, in terms of the application of force majeure. The pandemic and the prevention and control measures should be deemed to constitute force majeure. And here, clearly, a global pandemic is not the same as an epidemic. So therefore, yes, COVID-19 is a force majeure event. But what are what's the scope of force majeure? All the measures, for instance, I was this morning having a look at the different interpretations in the construction sector. So clearly costs and delays directly linked to COVID-19, for instance, when the construction has stopped completely, right, can be deemed as covered by force majeure. But for instance, an increase in the cost, right, is not considered force majeure, even if it's related to the COVID-19 crisis. And there must be a causal relationship between the pandemic and the parties' failure to perform the contract. And the party should not have a fault in the performance of the contract affected by the pandemic, right? So how do we apply this in terms of the global value chains, right? So it's quite complex, and so for the sake of time, I will be brief in the explanation, because I need to deal still with construction contracts, right? So, and perhaps we can have the opportunity to talk about this more in detail in the Q&A. So I think that the question of how we apply force majeure in terms of the international sale of goods contracts, which are being affected for different reasons, in particular in the government sector, right? Transportation issues, social distancing, and lockdowns, right? So we need to think that take a more flexible approach and to see what is really the cost-benefit analysis more convenient to do. Shall we suspend the performance of the obligations instead and renegotiating instead of terminating the contract? And I think that perhaps is a more reasonable option. So looking at the different issues there, right, and different solutions in the international sale of goods, right? So we can have the possibility to renegotiate the contractual terms. I think that it's crucial to have this assessment, right, of the consequences, as is stated there, duty to mitigate the losses, non-performance, right, in the case of non-performance, termination. I think that it should be kept as a last resort solution. Moving on now to have a look at the, because I'm mindful of the time, right? So at the construction sector. The construction sector, so before we were talking about more about the international sales of goods, government sector, construction sector, as I said before, differently affected, right? So again, in this case, there is no settled legal definition of what constitutes force majeure. We need to based our interpretation on the wording of the contract. And here, the precise wording used in the contract matters, right? So we have different types of construction contracts, and we have an increased standardization, for instance, JCT contracts and joint construction contracts construction tribunals, right? So which in turn comprise other types of contracts, right? So the contract is the law of the parties. We need to have a look at the list of potential force majeure events, right? And we need to see if the clause provides relief in those cases. And usually what we have in these cases is that we need to demonstrate that the force majeure hinders or prevents the carrying out of the goods. So it needs to be clear that in this case, the force majeure has an impact on the performance of the contract, right? So we have, again, the need for a concrete definition of force majeure. And in those cases, the clauses will give us the idea if the pandemic can be included with all its effects within the force majeure clause. It needs to be, again, beyond the contractor's reasonable control. And here there is an issue from a common law perspective, which is the application of the ejusdem generis rule, which is not applicable in these cases as a rule. So we need to be looking at the particular terms and the intention of the parties in each contract. So very briefly, and I will perhaps speed up a little bit, if I may. In terms of construction contracts, we need to have a look at the force majeure clauses. The specific wording is crucial. We need to give notice. This is something that, for instance, in English law, there are several cases in which the force majeure clause, even though contained in the contract, was not applicable because the party did not give notice. So the timing to give them, so as soon as we become aware of it. So I was talking about the cutoff date. So clearly the 11th March 2020 is a cutoff date for, or in terms of timing, right, the relevant date. Evidence, we need to gather as much evidence as we can in terms of demonstrating that there was force majeure. So, and then I think there the devil is in the detail. So the terms, in terms of, like, for instance, demonstrating that it was not possible to access the site because of lockdown rules and these kind of things. China has issued 3,000 certificates of force majeure, including the construction sector. And those certificates a valid proof or evidence? Well, not that much, right? So we need to be careful about evidence, right? So other coronavirus-related events or impacts, for instance, an increase in the prices, might not be considered force majeure, and in that case, so the question is who should bear the costs, the increased costs. And remedies, as in terms of remedies, we have suspension of the performance, and if we need to have a look at the case in particular, but we may also use frustration, but nevertheless frustration, quite high threshold. We have had a recent case in the English jurisdiction concerning frustration in the context of Brexit, and the threshold is very, very, very high for determination as a matter of law of the contract. So just to recap, in terms of construction contract, conditions for the application are crucial. Price differences might not be considered force majeure. Consequences of the application, again, well, we what do we want? Do we want a suspension of performance? Do we want to terminate the contract and claim the impossibility of performance? Yeah. So in what the minutes I got, I think I've got approximately 3 minutes, if I'm not mistaken. I want to talk briefly about the emerging court litigation. We are seeing an emerging court litigation with already interim measures. I think that one of the things that lawyers were doing, at least in Spain and here, was to apply for interim measures, right? So in cases in which they wanted to keep the factual or the legal situation and not to worsen the situation. But we have also an increase in arbitral case increase in arbitral cases involving both commercial and investment arbitration, in which the measures adopted by governments are being questioned, right? And which we have force majeure invoked, and it depends really in terms of commercial and investment arbitration, the different claims made there. In investment arbitration, perhaps there is more scope even for the question of state responsibility and right to regulate. So clearly there is an impact on arbitral proceedings, and I think that the impact I wanted to talk about is not only from the substance of the cases, because we are seeing now, for instance, it was very interesting in the London Chamber of International Arbitration, some cases already being filed with regard to lockdowns. I had a look at the recent case in India, right, in terms of like, if I'm not mistaken, in the textile sector, right, with regard to the performance, right, of the contract, right, and not taking the COVID restrictions and lockdown, right, into consideration. So that's the substance, right, of the cases. I think that COVID-19 has had an impact on the procedural issues, which we need to bear in mind. With the lockdowns being announced across the countries, clearly court litigation was not possible. Many lawyers were left with the option of arbitration. Many arbitration chambers, including my own chamber, which is the Madrid Chamber of Commerce, they continue working. And they moved very quickly online, and all the hearings were moved online. We had issues. Clearly, Zoom is not like being in the same physical room, but nevertheless, there was an option, and I think we are learning by doing. And we have learned different things. First of all, that in terms of costs, it is far less expensive to do an arbitration online. I think that it will be very difficult to get back to the previous normal, in that requiring a client to pay the expenses, including travels, right, to UK, Brazil, for instance. It will be very, very difficult after what we have seen, that we can deal with the hearings online. Second, we need to think about adjusting the arbitral rules to this new situation. Some chambers, like the German Chamber of Commerce, right, or arbitration, right, we were already thinking a year ago about changing everything to adjust to the online system, because there are problems. We have had cases of parties recording the hearing on Zoom, because you cannot control for that. But I think that in terms of the procedural aspect, this is more an opportunity. And yesterday at the International Chambers of Commerce in Miami, regional conference, we were talking with colleagues from other countries, right, and particularly developing countries, right? So, and the COVID-19 crisis has brought an opportunity for lawyers from emerging countries to have a participation, and more participation in proceedings, right? So I think that there is an issue there with regard to, which is a broader issue with regard to regional representation and diversity in arbitration. And what we could see is, because of the COVID-19 crisis, there are different ways of participate in arbitration, right? So, but it remains to be seen what is the final effect of COVID-19 on arbitration and on court litigation, right? So finally, to conclude, right, some final remarks, right? So I think that it is important to think about the robustness of contracts, of transnational contracts. As lawyers, we need to think about drafting a good contract and the resilience of transnational contracts, right? So in terms of how can we use the current wording, we cannot change the wording, but how can we use the current wording to address the issues? This idea, I will briefly mention 2 more points, and then I will hand it over back to Asanga, right? This idea of long-term contractual relationship, renegotiation based on bona fide, and using force majeure with caution, taking into account what is the final outcome that we want to achieve. And that's it. Thank you very much for your time. I look forward to the questions you may have. Thank you very much.
Belen, thank you very much for that very interesting and thought-provoking and information that you shared with us. And we have a few questions to put to you. And there are a couple of questions that have come from the audience and also from the listeners. And also I have a couple of questions as well. So let's get into the Q&A session, and perhaps you can throw more insight into some of these issues. Now, the first issue that I have for you, Belen, is that, as you know, with regard to the COVID-19 situation, it's undoubtedly a global pandemic. Mm-hmm. And in order to deal with this situation, as you know, in many countries, there have been statutory or regulatory measures that have been introduced. And in most of the transnational or international commercial contracts, in addition to having an escape clause or a mitigatory clause in the form of a force majeure clause, there is also a change of law clause, mm-hmm. which sometimes entitle the contractors, for example, to seek compensation from the government if the change of law takes place, saying that there's a new law or new regulation that is currently in place. So if a government, say for example, in an international contract involving a government entity and a private contractor, to deal with the COVID-19 situation, if the government introduces regulations like travel restrictions, export-import restrictions, and so on, and that has an impact on the project, despite the underlying reason being a force majeure reason, can the contractor seek compensation from the government? And how do you see the interplay between the change of law clause and the force majeure clause in that kind of situation?
Mm-hmm. That's a very interesting question. I don't have a full answer to that, right? But of course, I mean, what we have been discussing is it depends on the jurisdiction, but in civil law jurisdictions, we have something which is we have the act of God, but we have the act of the prince, which is in this case, the government, right? And in those cases, right, so I think that if you have a clause such as a change of law clause, right, so, well, I think you can try to seek for compensation, right? But one thing that we need also to bear in mind is that governments will argue that this is an emergency, a public emergency, and then therefore there was, from their perspective, right, an emergency, right? Playing the emergency card, right? So, of course, it depends on the country. There are countries in which, without asking the business sector asking for this, for compensation, the government has reached out to the business sector offering compensation for the measures adopted, right? And with some kind of like relief, like Germany, for instance, right? Or, well, the UK, for instance, the retail and the fashion and retail sector, right? But I think that, as I said, I don't have the full answer. I think that the question for claiming compensation from the government for a change of laws, which is possible, is that what would be the response from the government, right? Because this is a public emergency, right? So the government will try to argue that, right? That's a global health emergency and so on. And as I said, we need to be very careful about what type of effects we are talking about, right? So I don't know. I have answered your question. Your very interesting question. Yes.
Thank you. If the government is listening, I'm sure you might get appointed as an arbitrator in a dispute where the government is involved.
No, it's just what we have been discussing, right? So I mean, I suppose that that here there will be. I think in the case of the UK, for instance, thinking about the UK, right? If the lockdown gets extended, right, we will have more situations like that, right? So
true. Right. So I have another question for you, Belen. That is, in your talk, you referred to this principle of rebus sic stantibus. I think in English the translation it reads as things thus standing. Yeah. Right now, this stipulates that where there has been a fundamental change of circumstances, the party may withdraw from a contract or terminate a contract. Now, are you aware of any? This is necessarily a civil law concept, if I'm not mistaken. But are you aware of any instances where this concept has been applied in a common law jurisdiction?
No, I think that here we have a classical legal divide between common law jurisdictions and civil law jurisdictions, right? So I think the common law jurisdictions response is more frustration due to which is different. It's linked to the impossibility of performance, right? Due to an unforeseen or unforeseeable event. Here we're talking about a dramatic change of the circumstances, which alters, right, the equilibrium of the contract, right? And again, I think the common point in both is that the threshold is quite high. I don't know any cases in a common law jurisdiction in which the rebus sic stantibus has been invoked, because we have other remedies, right? So in civil law countries, even though we have that possibility, it can only be invoked if there is no other contractual clause applicable. Force majeure is not applicable either, and then we have that. But the threshold is quite high. For instance, in Spain, you need really to provide with exhaustive evidence that this is a considerable change in the equilibrium in the contract. In the case of the UK, for instance, which is no rebus sic stantibus but frustration, we see that you can claim or invoke frustration if it's unforeseen or unforeseeable. And now we are seeing cases coming from Brexit. There was last year a very interesting case between Canary Wharf, the States, and the European Agency, Medicines Agency, which moved the headquarters from London to Amsterdam due to the Brexit. And they tried to exit the tenancy agreement, the 25-year tenancy agreement, you know, Canary Wharf, most expensive place perhaps in London, and they invoked frustration in the European agency. So, of course, Brexit was unforeseen. So no one in 2011 which was the date of the contract, right, could have foreseen, or perhaps, yes, we could have expected that, but not foreseen really Brexit. But nevertheless, the court determined that it was not unforeseeable. Then, therefore, frustration was not upheld. Right? So, you see, it is, I think, the common point. So, first of all, rebus sic stantibus is more for civil law jurisdictions, not common law. We have frustration, but the common feature of both is a very extreme high threshold.
Thank you, Belen. There's one last question I'll put to you. This is from one of our listeners.
Yes.
This is in connection with the contract that might fall within the jurisdiction of the CISG, the Convention on International Sale of Goods.
Yes.
And the question is whether the provisions contained there in the CISG are sufficient to deal with the COVID-like situation, or do you see the need for any improvements to the CISG?
Well, I think it's a matter of interpretation, right? So I am in a jurisdiction, I need to teach international trade law to English lawyers, and we are in a jurisdiction which is not party to the Vienna Convention. So I think that it's a matter of interpretation. We can interpret the terms, right, in a way that we can find the remedies for the pandemic, but definitely we need to rely on extra sources like the UNIDROIT principles or the European contract law principles, right? So I don't think that the convention itself is sufficient to deal with the current pandemic, right? Of course, we can interpret the convention. I mentioned there the provisions, right? So, but I think that in terms of defining the effects, what is covered and what's not covered, right? We need to rely on additional sources. So then, of course, I mean, we can discuss, right? So we have here the Sale of Goods Act 1979, the Vienna Convention 1980. Yes, of course, we can be talking about the need for reform, clearly.
Okay, thank you very much, Belen. I think we have come to the end of today's session, so I will now invite Janaka to say a few words. But before that, as a parting remark, thank you very much for this, and perhaps in future we will try to collaborate with you again and listen to you on another interesting topic. And with that, thank you very much. Over to you, Janaka.
Thank you, Doctor. Ladies and gentlemen, we have now come to the end of our allocated time for this today's interesting webinar. Thank you very much, Dr. Belen and Dr. Gunawan for that enlightening discussions on transnational contracts and the impact posed by COVID-19, which I'm sure will be of much use given the uncertain times that we are all living around. I would also like to sincerely thank Dr. Belen for joining us today, despite time differences, and her enthusiasm and interest in this webinar. I heard that Dr. Belen was supposed to visit Sri Lanka this year had there not been COVID. So we do hope that you will be able to join us, visit Sri Lanka physically in the near future. And my sincere gratitude goes also to the President of the Bar Association of Sri Lanka, Mr. Kaling, this President's Council, and the Secretary, Mr. Rajiv Amarasuriya, and the Assistant Secretary, Mr. Pasindu De Silva, for helping us in organizing these events. Also, ladies and gentlemen, I must thank you for participating in today's event, and also please do tune in on our next webinar, which will be held on the 16th on international arbitration and how building a career in international arbitration and alternate dispute resolutions, which will be presented by Dr. Sundar Raju. This will be at 3:30 p.m. Sri Lanka time on Monday the 16th. And also on 19th, we'll be conducting another very interesting session on new legal frontiers when it comes to cryptocurrency and latest international developments in relation to commercial and criminal law, which will be conducted by 5 experts speaking to us from the UK. Thank you for tuning in, and I do hope that you will have a pleasant evening. Goodbye.